My name is Tina Valerie, and I'm the Chief of Administration and Licensing here at the board. I would like to take this opportunity to welcome you to our Dental Assisting Council special training session. It looks like we have everyone connected and are ready to begin. So at this time, I would like to turn the training session over to Dr. Stewart. He will be addressing agenda item 1, which is the welcome and introduction of Dental Assisting Council members.
Thank you, Tina. And can you hear me?
Yes, we can.
Okay, thank you. Well, good morning, everyone, and thank you for joining us for the Dental Assisting Council special training session. My name is Dr. Thomas Stewart, and I am president of the board. Today is Thursday, December 3, 2020. This Dental Assisting Council special training session is being held via WebEx. Pursuant to the provisions of Governor Newsom's Executive Order N2520, dated March 12, 2020, neither a public location nor teleconference locations are provided for this meeting. For all of those who wish to participate, please log on to the WebEx website provided on the posted agenda for this training session. Instructions to connect to the training session are provided on the agenda. The preferred audio connection is via telephone conference and not the microphone and speakers on your computer. The phone number and access code will be provided as part of your connection to the training session. Since this training session is being conducted via WebEx, I will ask all Dental Assisting Council members and speakers to announce themselves by name before speaking for clarity of the official record. All Dental Assisting Council members are able to unmute themselves to speak during the meeting. Please place yourself back on mute when not speaking to reduce background noise for all participants. Following such online meeting etiquette will ensure the best audio quality for everyone. During each call for comments from Dental Assisting Council members and speakers, we will ensure that all comments that can be accommodated are heard before proceeding with the agenda. We will be taking a 15-minute break in the morning, a 30-minute lunch break, estimated to occur between noon to 12:30, and another 15-minute break following in the afternoon if needed. This is an official training session for the Dental Assisting Council. There will be no public comments throughout this training. I will ask all Dental Assisting Council members to please refrain from asking questions until we reach the end of each agenda item. You will be given a chance to comment and ask questions after board staff's presentation. At this time, I would like to ask the board staff to please take the roll to confirm the Dental Assisting Council members who are present for this special training.
This is Fahua, the board's administrative analyst, and I will now call the roll. Cazares.
Present.
Present. Fowler.
Here.
Present. Jawad.
Present.
Present. Miyazaki.
Present.
Olagi.
Olagi, present.
Pacheco.
Present.
Reed Espinoza.
Present.
Present. Mr. President, all Dental Assisting Council members are present for this training.
Thank you, Fahua. And thank you. And at this time, I would like to now introduce the new members who are appointed to the Dental Assisting Council in July of 2020. First, we have Ms. Jerry Fowler. Ms. Fowler is a certified dental assistant, registered dental assistant in extended functions, and orthodontic assistant. She received her associate degree in dental assisting from Chaffey College in 1984. Ms. Fowler worked as an RDA in general private practice from 1984 through 1987, and then worked as an orthodontic assistant from 1987 to 1989. She started working at Loma Linda University School of Dentistry in 1989 as assistant supervisor in the graduate endodontic department. She received her designated subjects CTE teaching credential from California State University, San Bernardino in 2010, and taught part-time at Riverside County Office of Education and Chaffey College in their RDA programs from 2010 to 2017, while continuing to work full-time for Loma Linda University School of Dentistry. In 2004, Ms. Fowler started working for the Continuing Dental Education and Alumni Department at Loma Linda University School of Dentistry as an assistant director and continues to do so today. Ms. Fowler graduated from University of California, Los Angeles, and received her RDA-EF license in 2014. She is also the founding director of the LLU RDA-EF program and the orthodontic assistant programs, which she started in 2017. She is a member of the California Association of Dental Assisting Teachers, American Dental Assisting Association, the California Dental Assistants Association, and the Pomona Valley Dental Assisting Society. The next member is Ms. Michelle Jawad, and I'm Michelle, I hope I'm pronouncing that right. Ms. Jawad is thank you. Ms. Jawad is a registered dental assistant and has been in the dental field for 25 plus years. She has been an assistant, manager, and staff trainer for a large private practice in North Berkeley. She has been an RDA instructor at both Heald and Carrington colleges. Over the years, she has been on various dental committees and boards, including the California Dental Association as an allied representative, and the California Association of Dental Assisting Teachers as a board member. Ms. Jawad was a contributor for Elsevier Evolve on a textbook on professionalism in the dental field. She is currently a clinical supervisor for University of California, San Francisco, International Student Pathway, and a part-time instructor for Tooth Fairy Systems. She holds a bachelor's degree in healthcare administration and a master's degree in education. Next, we have Ms. Kara Miyazaki. Ms. Miyazaki has been director of the Foothill College Dental Assisting Program for 29 years. She received her certificate in dental assisting from Foothill College, a bachelor's degree in dental hygiene, and a master's degree in oral biology at the University of California, San Francisco School of Dentistry. Ms. Miyazaki attended UCSF for her RDHEF education and also received a certificate in educational technology from the University of California, Santa Cruz in 1999. From 1924 to 2008, she taught in the RDA-EF program offered at the UCSF School of Dentistry. Ms. Miyazaki has been a training consultant for Invisalign and eHuman 3D tooth educational software. Her publications include the 5th revision of Chastain's Essentials of Clinical Dental Assisting and Risk Management for the Dental Assistant. She has also published several chapters for dental hygiene theory and practice. She is a member of the American Dental Assistants Association, the California Dental Hygienists Association, the American Dental Education Association, the California Dental Assisting Teachers Association, and is the co-founder of the Dental Assisting Educators Group. And lastly, we have Ms. Tracy Reed Espinoza. Ms. Reed Espinoza began her dental career at Oregon Health and Sciences University, where she earned her Certified Dental Assistant's license in 1982. She then earned her Orthodontic Assistant certification in 1985, her Oral Surgery Assistant certification in 1996, and her Phlebotomist certification in 1999. She continued to further her dental education in 2014 and received her RDA-EF license. Her strong presence in the dental community earned her a staff position at the Charter College in Oxnard, California in 2017. In the past, she immersed herself in the academic community as an instructor of the EFDA2 program in Montecito, California. Ms. Reed Espinoza has devoted herself to teaching others and giving back to the dental community. Teaching and helping others grow in the field of dentistry is a great passion of hers as she continues practice and holds an integral leadership role at Montecito Dental Group, a general dental practice in Montecito. So it is my pleasure to welcome you all to the Dental Assisting Council. You each play a critical role in fulfilling the Council's responsibility to consider all matters relating to dental assisting in the state, on your own initiative or upon the request of the board. My colleagues on the board and I look forward to working with you toward the common goal of public protection. I would like to thank the executive team and the Dental Board of California staff for organizing this training session. And after reviewing the qualifications of these new appointees, I believe that we are looking at great opportunities to advance and represent the dental assisting part of the dental family, which we all agree is a vital part of keeping our public safe and well served. This concludes my remarks. And at this point, Ms. Tina Valerie, Chief of Administration and Licensing, will take over in facilitating this training. Thank you.
Thank you, Dr. Stewart. I will now be presenting Agenda Item 2, Overview and Functions of the Dental Board of California, and Agenda Item 3, Overview and Functions of the Board's Dental Assisting Council. I will begin by providing you with a brief overview of the Dental Board of California and the functions of the board. The board is responsible for the licensure and regulation of dentists, registered dental assistants, and registered dental assistants in extended functions, in addition to various permit holders. They serve the purposes of their licensing and regulatory functions by reviewing applications for licenses and permits, issuing licenses and permits to qualified candidates, and by assuring initial and continued competence. We receive complaints for consumers, investigate those complaints, and take the necessary disciplinary action against those licensees and permit holders that violate the Dental Practice Act. The board also monitors licensees placed on probation and is responsible for managing a diversion program. The board's mission is to protect and promote the health and safety of consumers in the state of California. We accomplish that mission by ensuring that we are issuing licenses to competent applicants that possess the necessary educational requirements and have met all of the licensure and examination requirements to be issued a license in California. We enforce the continuing education requirements and ensure that consumers are informed of their rights in relation to verifying dental licenses and their ability to file a complaint and how to file a complaint with the board. As it relates to consumer complaints, we open all complaints made to the board and will promptly and thoroughly investigate those complaints. If there is a warranted violation of the Dental Practice Act, this could be cause for disciplinary action through the Attorney General's office. The board itself usually meets at least 4 times per year, usually in San Francisco, Los Angeles, San Diego, and Sacramento. However, in response to the COVID-19 pandemic and pursuant to Governor Newsom's executive order, the board is currently conducting its meetings via teleconference to make the meetings accessible to all members of the public while still allowing participants to physically distance. The board has several standing committees. There is an examination, anesthesia, and enforcement committee, a licensure, permits, and certification committee, a legislative and regulatory committee, an access to care committee, a substance use awareness committee, and the Dental Assisting Council. The board can also create additional committees as needed. And before I proceed to the next agenda item, I'd be happy to answer any questions you may have about this topic. Okay, seeing no questions, I will move on to agenda item 3, which is the overview and functions of the Dental Assisting Council. The council was established by Senate Bill 540 in 2011, and the initial council appointments were made in 2012. The establishment of the council is contained in Business and Professions Code Section 1740 of the Dental Practice Act. In that code section, it outlines what the responsibilities of the council are, what the composition and requirements of membership are, etc. The council is comprised of the RDA member of the board, another member of the board, and 5 RDA members, one of which must be an RDA EF. The appointments to the council are made by the dental board, and we accept applications from qualified candidates. Typically, a subcommittee reviews those applications and makes recommendations to the board for appointment. As established in statute, the council is responsible to meet in conjunction with other board committees. Typically, this only happens at the quarterly board meetings. In the recent past, we have been holding joint meetings with the full board and the Dental Assisting Council, though this is dependent upon what issues come forth. The council meeting agenda items are established through the board president and the executive officer. Should any council members or stakeholders wish to request the establishment of an agenda item for future board meetings, the request should be sent to the board president and the executive officer for approval and placement on a future agenda. And I'd be happy to answer any questions you may have. Okay, seeing no questions, we'll now move on to agenda item 4, overview of the board's dental assisting program, and agenda item 5, the board's and the council's role in the protection of the public. I'm going to ask Amelia Zuloga, dental assisting program manager, to present both of these agenda items.
Good morning, everyone. Agenda item number 4, the overview of the dental board's assisting program. As Tina mentioned, I am the licensing manager over the dental assisting program. This program is responsible for the licensure and examination of all RDAs, RDA EFs, and also the orthodontic assistant permit and dental sedation assistant permits. So I manage the examination processes for all of those licensure categories. The licensure application processes for all of those categories, as well as the renewal and the continuing education requirements. So just a little more of an overview of the functions of the program. We have several staff that review the applications, and they also travel to the examinations to administer the RDA EF. We have several renewals that we're processing. We process all of the fingerprint results that are required as a result of the initial licensure and renewal. And we are a unique program where we are reviewing and approving the program and course applications for dental assisting education. So how did the dental assisting program come to be a part of the board? Initially, the dental assisting program was part of the Committee on Dental Auxiliaries. There was a bill in 2008 that essentially abolished the Committee on Dental Auxiliaries and created the Dental Hygiene Committee of California, which moved the dental assisting program under the board as of 2009. So since 2009, we've made several changes, significant changes in the scope of practice and the requirements for licensure as a result of AB 2637, which became effective in 2010, and we've been revising dental assisting educational program and course regulations that have, been effective since November of 2011. I'm happy to answer any questions on agenda item 4. Okay, I'm not seeing any questions. Agenda item 4A is the update on new dental assisting program and course applications. The top table on this slide shows the DA program and course applications approved in 2020, which total 51. The bottom table shows that there was one RDA program site visit in 2020. Continuing with the update on new dental assisting program and course applications, this table shows the RDA program and course application status for 2020. So as you can see, the table is broken down by program course type, and I will review the totals. The total approved is 51, 0 were denied, 1 has its curriculum approved but it's pending a site visit, 6 are in the review process, and 15 are currently deficient. For the last slide on this agenda item, this table shows the total approved RDA programs and courses. This reflects the number of programs or courses which are currently active. And I'd be happy to answer any questions about agenda item 4A. Okay, I'm not seeing any questions.
Kara Miyazaki.
Sorry?
Kara Miyazaki, I wanted to ask a question about the slide. So I'm looking at the ultrasonic scalar courses and the ortho assistant permit courses, and it was my understanding that the ortho assistant permits required ultrasonic scaling to be part of their permit. So I'm seeing a disconnect between the number of 112 ortho assistant permit courses and the ultrasonic scaling courses.
Hi, this is Tina Valerie. So the reason that there's a disproportionate amount is because orthodontic assistant permit courses can have ultrasonic scalar within their program and not have standalone approval. So the 18 courses that you're seeing for ultrasonic scaling are actually standalone approved courses, and the orthodontic assistant is the actual orthodontic assistant course, which could also include ultrasonic scaling, and they may not be interested in doing a standalone course.
Okay, thank you.
Okay, if there's no other questions, I will continue with agenda item 4B. Agenda item 4B is the update on RDA program reevaluations. The board has the authority to reevaluate programs and courses to ensure compliance with regulations in the event the board deems it necessary. Board staff began the reevaluation process with RDA programs in February 2018. Between February 2018 and February 2019, 59 programs were identified for reevaluation. The order of the programs to be reevaluated was determined by the Law and Ethics and the RDA written examination statistics, using the school or program's overall pass-fail rate and the year the program was given full approval. Since then, the board has completed the reevaluation process for 47 programs. 34 programs have successfully demonstrated compliance with the Dental Practice Act and will maintain their approval with the board, and 13 programs were identified as being closed. 12 programs are currently in the reevaluation process. And I'd be happy to take any questions on agenda item 4B.
Kara Miyazaki, again, sorry. I wanted to ask a question about the subject matter experts who are looking at the program reevaluations and what their requirements were, and also if there's conflict of interest requirements too as well. Like, let's say if they're a CODA site visitor, is it possible for them to be a subject matter expert?
Hi, Kara. This is Tina Valerie again. I'm sorry, I didn't hear the last part of your question. I did hear the question about the conflict of interest, which they do sign a conflict of interest agreement with the board. The qualifications I don't have with me at the moment, but I could definitely send those to you. And if you would like to repeat the last part of your question, I'd be happy to try to answer it.
I was just I'm sorry. So I was just asking about, and I think that will be part of the stuff that you'll send me, but I was asking about conflict of interest that were kind of across the board for the subject matter experts. For instance, if someone is a CODA site visitor, is it possible for them to be a subject matter expert if they do site visits for the Commission on Dental Accreditation?
Hi, good morning. This is Anthony Payne. I hate to jump in here, but I'm going to actually be giving a presentation on conflicts of interest in a little while. But I can just, rather than keep you in suspense, something that factually nuanced, I would encourage you to work with the dental board legal counsel to kind of iron out whether that's something that's problematic or not. A lot of these things, as you'll find out in the presentation I'll give a little bit later, is they're very factually nuanced, and there isn't a lot of categorical yeses or nos in certain things, especially when it comes to conflicts of interest. So I hate to give you a non-answer answer, but that's probably the best we can do without really examining the facts closely, if that helps.
Kara Miyazaki again. Thank you very much. I appreciate that.
Thank you. I will go ahead and continue on to agenda item 4C. Agenda item 4C is the update on dental assisting examination statistics. This table provides the written examination pass and fail statistics for candidates who took the examinations from November 2019 through October 2020 for all candidates. To run through a few of the numbers, 64% of the RDA combined candidates passed the written exam, 77% of RDA EF candidates passed, 45% of orthodontic assistants, and 82% of the dental sedation assistant candidates passed. To continue with the dental assisting examination statistics, the following tables provide the written examination pass and fail statistics for first-time and repeat candidates who took the examinations from November 2019 through October 2020. Again, I will run through some of the percentage of candidate pass numbers. For RDA combined, it is 74% for first-time versus 49% for repeat candidates. RDA EF is 82% for first-time and 60% for repeats. OAs are at 56% first-time versus repeat candidates at 35%. And DSAs are at 89% passed for first-time and 50% for repeat candidates. Are there any dental assisting council member questions or comments about item 4C? Okay. Lastly, agenda item 4D is an update of dental assisting licensing statistics. The following tables provide current license statistics by license type as of November 2020 and current permit status statistics by permit type. Current and active refers to an individual who has an active status and has completed all renewal requirements. Current and inactive refers to an individual who has an inactive status, has paid the renewal fees, but cannot perform the duties of the license unless the license is reactivated. Continuing education units are not required for inactive license renewal. Delinquent refers to an individual who does not comply with renewal requirements. Canceled refers to an individual who fails to comply with renewal requirements by a set deadline, and deficient refers to an application processed lacking one or more requirements. Continuing with licensing statistics, this first graph shows the dental assisting applications received January through October 2020. The blue bar is the RDAs, the red is RDA EFs, the green is OAs, and the purple is DSAs. And again, this is for applications received. This second graph shows the dental assisting applications that were approved January through October 2020. The red is RDAs, the green is RDAES, the purple is OAs, and the blue is DSAs. This is dental assisting applications approved. And the final graph shows the dental assisting licenses that were issued January through October 2020. The blue is RDAs, the red is RDAES, green is OAs, and purple is DSAs. And I'd be happy to answer any questions about agenda item 4D. Okay, I'm not seeing any questions, so I'll move on to agenda item 5. Agenda item 5 is the role in the protection of the public. The board and the council's priority is the protection of the public. We do this in exercising all of our licensing, regulatory, and disciplinary functions, and it's important to note that whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. And we exercise this mission in everything that we do with the dental board. And I'd be happy to take any questions about agenda item 5.
Hi, this is Tina Valerie. Seeing no questions, we will now move on to agenda item 6, presentation and overview of the Bagley-Keene Open Meeting Act, and agenda item 7, presentation on and overview of conflicts of interest. I'm going to ask Anthony Payne, DCA Legal Counsel, to present these agenda items.
Good morning, everyone. Thank you for having me. As mentioned, I've been asked to provide sort of a high-level overview on the Open Meetings Act, and will also provide a presentation on conflicts of interest. You can go to the next slide, please. Thank you. So I wanted to first touch on the basic public policy behind our Open Meetings Act, and it's there in the government code. But in short, it's to make sure that the people's business is being done open and in front of the public and is transparent. As we will briefly touch into, most of what you're going to do is, in fact, I think actually all of this committee's work is going to be public and open. There are exceptions for closed session requirements under the law, but I don't believe at this point that this committee is going to be delving into those, which is much easier for you. So I just want to highlight behind the public policy that the point of what you're doing is to have these requirements that we're going to touch on very briefly here, but that we're doing it in public. So here's what the public has rights to: a notice of meeting and an agenda, to attend, to comment on each agenda item, to not identify themselves, and to inspect the public records that are related. So a couple things on these. As you'll know, you may know this already, we publish an agenda beforehand, 10 days before. We'll get into some of those details. Oftentimes, the chair of the committee will may request that that the person identify themselves, but of course that's not required. And also, we always make sure to ask for public comment in case there is any for each agenda item. Next slide, please. So, what is a meeting? Any congregation of a majority of the members of a state body at the same time and place to hear, discuss, or deliberate upon any item that is within the subject matter jurisdiction of that state body. And that's what you are. You are a state body, and this would qualify as a, quote, meeting. Next slide, please. This means you. So what I want to make sure we do is, and I'm happy to provide this to all the committee members, this presentation, if they want this, even though this is an overview, it does provide statutes and references. I'm happy to provide those to you. But I do want to just underscore and kind of talk about the high level piece. But you are considered a state body. I want to underscore the fact that there are even committees that are a subset of the main board are still considered state bodies. Next slide, please. And here we are. So again, committees are state bodies. There is a limited exception with an advisory committee with less than 3 persons without any delegated final authority. So I want to highlight that point. Not all advisory committees fall into this exception. It's an advisory committee with less than 3 persons without any delegated final authority. And so we want to make sure that you are still following these Bagley-Keene requirements because generally most advisory committees, unless they're created sort of ad hoc at a sort of usually by motion of a board, and as again, it satisfies these requirements. In that case, Bagley-Keene wouldn't apply, but we want to make sure that you all are aware of these rules because we would want to make sure that the Bagley-Keene requirements apply to this committee. Next slide, please. So here's a little bit more detail about the notice. At least 10 calendar days posted in advance. We provide the time and location. We include the agenda and we notify if the meeting is webcast. Now, I will have a few slides that will talk about sort of the COVID environment, and there are some exceptions that apply, but this is the general rule. And, eventually when we do come out of COVID, we would sort of defer back to these requirements. Next slide, please. If the item isn't on the agenda, the committee or the board should not hear, discuss, or deliberate on it. It's also important that we try not to bunch up a bunch of agenda items and that we deal with each agenda item individually and separately. Next slide, please. So what needs to be on the agenda? Items of business. Are we providing a presentation? Is there action that's going to be required? What we might see is that the committee might deliberate and propose a recommendation. Those are action items. So we want to make sure on the agenda we're as clear and specific as possible. So here's an example. Public comment items not included on the agenda. We also want to make sure we have those. So we may have specific action agenda items on the agenda, which we want to have and we want to be specific about. But we also want to make sure that we have one agenda item that says there's public comment for items not on the agenda, in case there's other items the public wants to talk about and encourage the committee to maybe make it as a future agenda item. You can see, I hope, that it's a little bit more antiquated, but the reference to old business and new business or anything that's sort of related to that, we want to avoid being vague and generic. It's okay to be specific. Sometimes what I hear concerns from committee and board members is, well, if we're too specific, then we can't talk about anything else. So here's what I would recommend. The chair is always free to work with program staff on exactly what the topics are. We can frame it in a way that allows for robust discussion, but we do want to also be as specific as possible so that the public knows exactly what it is we'll be discussing. Next slide, please. So we have to make sure that we allow public comment on each item, as I mentioned before. Okay, it's okay, for example, we may get very popular items where the public will want to discuss, and you might get a lot of public members. So it's okay to, as mentioned there, we can allot reasonable time for the comment, maybe 2 minutes per speaker. That's okay, but we do want to make sure we provide that. Okay. And as you may already know, we want to make sure that votes are tallied in public and open. let me pause just for a moment. I know I was kind of going quickly through this. Does anybody have any questions thus far on what I've been able to discuss?
Kara Miyazaki, on the previous,
Yes.
can you elaborate on the second from the bottom bullet? Consider agenda wording. What is anticipated outcome? Could you specify?
Is that, I'm sorry, which slide was that on?
The previous one to this one. The second from the bottom bullet.
Consider agenda wording. What is anticipated outcome?
Yeah, can you?
Sure. So the problem with this sort of phrasing is it doesn't really explain what's going to happen by the committee. Is the committee going to essentially take an action item? Is this going to be, for example, staff recommendation? Is that going to be voted on or not? So what is the anticipated outcome? Answering that question is something that you would have as normal discourse among the committee. So that in and of itself isn't would not be encouraged, I think, as an agenda wording item, if that makes sense.
Anthony,
does that help?
Anthony, this is Karen Fisher. I'm going to just jump in here and give an example. So on our agendas,
okay.
I know that many members have been following our board agendas, and we've duplicated it on the dental assisting council agendas. But typically, if there's action, we'll say discussion and possible action, and then we should, in the agenda item, be as specific as we can about what we're going to be discussing. And I think that folds into what Anthony is trying to say. So the more specific we can be, the better. There will be agenda items that may say something like update. So we don't expect that there would necessarily be, for an update, of course, we'd take questions, but an update typically doesn't ask for any actions to be taken. So I think that's what Anthony is trying to get at, and those are examples of how we do it.
Does that help?
Yes, Kara Miyazaki. Yes, that does help a lot. Thank you so much.
That slide was more about how do we phrase things on an agenda and what does that communicate to the public?
Thank you.
Okay.
Question.
Yes.
Who appoints the advisory committees? Is that something that's only allowed by the dental board, or is that something that can be done within the dental assisting council?
Well, I think at the beginning this morning, one of the presenters was mentioning the statutory authority for the Dental Assistance Council. So it can exist two ways. It can exist and be created by statute, be created by a state body. And so I believe, if I remember hearing this correctly earlier this morning, the Dental Assistance Committee was created by statute. And Karen can correct me if I'm wrong, but I believe, and as created by statute, we would want to make sure that the Bagley-Keene Open Meetings Act applies, and that's how the meetings are conducted.
That's correct.
Thank you.
We can go to the, unless there's any more questions, sure. Okay. Let's go to the next slide, please. So I'm going to briefly touch on closed session. I just want to make sure that you're aware that that exists. Again, as I mentioned, I don't anticipate that being an issue for this particular committee, but I do want you to be aware, just to kind of have the full perspective of the Open Meetings Act, that most of what a state body does is open to the public, and there are some specific exemptions that exist that allow a state body to go into closed session to deliberate. Okay. So the next slide, please. And that's what I've mentioned here. Here's some of the examples. And again, I don't anticipate any of these bullets applying for this particular committee. I do want to highlight, and I know this this may sound hilarious for me to highlight, but I do want to make sure that just because something is embarrassing or controversial, that in and of itself isn't a statutory authority to go into closed session. So I just wanted to point that one piece out. You can go to the next slide, please. So teleconference meetings. So, and we'll talk about COVID situations now, but the location generally pre-COVID needs to be specified on the agenda. Okay. Yes, your home address, if that's where you're calling from. Okay. Let's go to the next slide, please. So what we would recommend that if you have some concerns about listing your home address, that what has often happened is we schedule other locations that are public locations that are ADA accessible, and we can work with the committee to have multiple locations if that would help. I hope we all can see why, bars, private clubs, Starbucks aren't real locations to conduct public business. So we want to obviously discourage those sorts of locations for meeting places. Next slide, please. So where we do have it posted, where we do have a location, we do have to have the agenda posted. That's, of course, letting the public know that this is where a particular meeting of this state body is being conducted. And we have to have sufficient equipment to conduct the meeting. So we have to be able to have a way of letting a member of the public come to that location, speak on a particular agenda item. So there may be some logistics that also have to be worked out. So this is why we want to work far in advance if we can to make sure the location's appropriate and we have everything needed for it. Next slide, please. Okay, if the member leaves the location before the end of the meeting, the location must stay open. So I want to highlight that point. What we try to do is we try to make sure that the member remains in that location if possible, to help facilitate that meeting location. But if we do have a situation where they leave, that doesn't mean that location then comes off. We've posted that location as an agenda on the agenda, and that is a place where the public's entitled to be. So we want to make sure that that wouldn't go away simply because the member happens to leave that location. But we want to encourage and discourage the situation where the member does in fact leave, if possible. Next slide, please. So some things obviously have changed because of COVID, a lot of these requirements. WebEx is certainly one of those new changes that all of our boards and committees have sort of adapted to. But one of the things that we've started holding these meetings, we're not listing, and this is through our executive orders from the governor, that we don't have to list the particular address locations. And a bit of the rationale behind it, when we're moving to sort of an electronic location where members of the public can log in from wherever they are, the physical location becomes less of an impairment to public participation. Next slide, please. Okay, even in the COVID environment, the notice still has to give the advance notice of the public meeting. We still have to post the agenda in the 10 days. We still have to make sure that we provide that notice of means by which the public may still observe and offer public comment for each of the agenda items. So most things haven't changed. There have been a few changes due to COVID. Next slide, please. So here's what for public accessibility. the board or committee still has to implement procedures to receive and resolve requests for reasonable accommodation. You will note that in the agenda, there is reference to that specific requirement. That has not changed. Okay, let's go to the next slide, please. So special meetings. Don't anticipate having some of these, but I do want you to be aware that these meetings do exist. And if for a particular purpose that's, again, under the statute that allows for special meetings, you can provide at least 48 hours notice, which is very different than the 10 days, right? But there has to be an urgent reason and a sufficient reason why we would call for a special meeting. Most cases, I mean, that is not how boards and bureaus and committees run meetings. We tend not to have very many special meetings. Again, there has to be that satisfied reason for holding a particular special meeting. Next slide, please. So at the beginning, I wanted to make sure that we talk about public participation. That's the biggest reason for why we should be conducting things according to the Open Meetings Act. We are doing more webcast meetings, and everything is recorded. Any meeting is recorded. Even when we were holding the in-person meetings sort of pre-COVID, those meetings were recorded. So we want to make sure that, and there's a record, so we want to make sure we're complying for that reason. But we also obviously want to make sure that we're giving the public the greatest amount of transparency and public participation as possible. And the best way to do that is to make sure that we're following these rules. Slide, please. So if we didn't follow these rules, besides it being a misdemeanor, the decision or action that's being taken by that state body can be invalidated. And so that is yet another reason why we want to make sure that we're adhering to these rules. Okay, I'm not sure if there's any, is there another slide? Is that it? Okay, but so before we go into conflicts of interest, does anybody have any questions of the Bagley-Keene Open Meetings Act? I know it was a high-level overview, but.
Anthony, this is Karen Fisher again. Thank you very much for that. That was very clear, I think. But what I also wanted to emphasize was this idea that through the executive order, we have the ability to do these WebEx meetings. This is a big deal. Not only does the board save money with not having to travel, we appear to have more public participation via this format because people can call in and participate in the meeting from wherever, and most of them are sheltering in place at home these days. So I think that our board is going to be seeking legislation, or perhaps other boards will also do the same thing, to allow for changes in statute to Bagley-Keene that will allow boards and committees to utilize this even beyond the executive order at least a couple of times throughout a year, because it is very convenient. As you'll see, it certainly saves time. It allows the board and council to still be able to conduct business, and it oftentimes is more efficient because perhaps a meeting can be done in a shorter amount of time, and you take out the travel time. So this is a really big deal. And so we are going to take advantage of that in the coming year. It's likely that the board will not and the council will not have in-person meetings at least through the first 6 months of next year. And we'll be determining when we get back to in-person meetings. I'm sure that will be associated with the distribution of the vaccine and whether COVID can get under control. So I think you did an excellent job, Anthony. I thank you very much for that presentation. And now we'll look to see if any council members have any additional questions at this time.
Great, my pleasure.
We've been kind of wondering when to take a biofluid break, and it's about 10 o'clock. Is this a good time? I want everybody to be comfortable as we go into the conflict of interest discussion. Does anybody, what are thoughts about taking a little 15-minute break now before we go into conflict of interest? Does staff want to weigh in?
Yeah, this is Dr. Stewart. I think 15 minutes would be fine. I would suggest that we do.
Okay, let's take a 15-minute break now, because as I said, I want people to be pretty comfortable when Anthony continues with conflict of interest. Anthony, are you good on time for that?
Oh, absolutely, no problem.
Okay, then moderator, let's take a 15-minute break. Coming back at that'd be 10 after 10. Thank you all.
We are ready to resume on the staff side.
Sarah, thank you. This is Dr. Stewart. Do we need to take the roll?
Yes, let's do that just to check. I'll go ahead and call. Is Anthony Payne on the line and ready to begin as well? Okay, I'll take the roll to make sure that the council members are on, and then we'll come back to Anthony. Olagi?
Present.
Kazaris?
Present.
Fowler?
Present.
Jawad?
Present.
Miyazaki?
Present.
Pacheco?
Pacheco, present.
Reed Espinoza?
Present.
Okay, we have all of our council members on the line. Anthony, have you returned? I'm going to mute and just call. We may be having a connection issue. Please hold 1 minute. Anthony, just checking one more time. Are you able to connect? You may be muted.
Hi, good morning. Again, I'm here.
Okay, we're ready to begin. Thank you, Anthony.
Oh, let's go. You can hear me now. Okay. One of the things I wanted to, before we get into this topic, I'm glad we had a little bit of a break, is I know Karen probably knew this. This gets a little bit more dense. I am going to still try to make it pretty high level if possible. I just want you to be aware that there are a couple of different perspectives to be thinking about when we're talking about conflicts of interest. There's really sort of four smaller areas, and I don't want you to feel apprehensive about the four areas. Every one of these, as I mentioned earlier this morning, is going to be very fact intensive. So this is more about just for awareness for you all of how, again, the general landscape. And this is under the Political Reform Act, and the Fair Political Practices Commission is the enforcement agency department for enforcing the Political Reform Act. They have statutes and they have regulations that have all kinds of definitions and further clarifications for things. So again, this is not something where you're going to become an expert in this. There's a department devoted to just this interpretation for conflicts of interest. So this is, again, just more of wanting you to see the landscape of this area. And there is a lot to it. So generally, conflicts of interest, as I mentioned, are under the Political Reform Act, and it requires disclosure of economic interests that could be an official action you make in your official capacity. And we are going to talk about Form 700 separately here in a few slides. That is the main document form that is the disclosure that you make that communicates to the public what your interests are, and that that the public's entitled to see regarding any official decisions you make. Let's go to the next slide, please. So where it's not, where conflicts of interest aren't specifically called out by statute or regulation, but maybe in case law, that's what's referred to as the common law conflicts of interest. And so we want to make sure that, I just want you to be aware, that's also a place where we might look to see if there are certain disclosures that you need to make, or, as mentioned, disqualification. What disqualification means is for a particular vote, you may not be able to vote yay or nay. That's the disqualification piece. Let's go to the next slide, please. Incompatible work activities. So that's another subset of the conflict of interest where you're engaging in a particular line of work that's in conflict or prohibited from your official action. And normally, prior to appointment, we try to make sure that those sorts of things are anticipated and worked around. But that said, we still want to look at those if that issue ever comes up. Let's go to the next slide, please. Okay, contracts. Public officials are prohibited from having a financial interest in any contract made by them in their official capacity. Okay, again, this is another sort of broad subset of the conflicts of interest landscape. So we want to make sure that you're not voting on a particular contract that might have an economic benefit to you or your partner. That, again, would be prohibited under the Political Reform Act. Next slide, please. Here's the main statute in the Political Reform Act. That public officials shall not participate in making or in any way attempting to use his or her official position to influence a governmental decision in which they know or have reason to know that they have a financial interest. Okay. Next slide, please. And we're going to get into a little bit of the weeds, but again, and you can have this, I can get you this presentation for reference if you'd like to have the citations, but generally you're going to have a financial interest in a decision if it's reasonably foreseeable that the decision will have a material effect on that official, okay? And there's a whole host of examples and definitions, regulations on and examples for what material effect is, what reasonably foreseeable is. So again, not something we're going to delve into today. I just want you to kind of have a broad sense of what the main sort of threshold is. Next slide, please. Here are some types of financial interests, and they're sort of the main ones. And here's the amounts where we would be reporting them, specifically on your Form 700. Okay, next slide, please. And we are not going into a 4-step process, but as I mentioned at the beginning, the Fair Political Practices Commission is the department that goes into a deep analysis if there is a potential conflict of interest. I want you to know that there's a 4-step process around that main definitional statute that we talked about a few slides ago. And that's what the FPPC is going to look at, whether there's a material effect to a financial interest that you're going to participate in your official action. Next slide, please. Okay, so now we're going to talk about the Form 700. And as I mentioned previously, the Form 700 is going to require you to provide disclosures to the public. Okay, next slide, please. These disclosures are for designated employees, for which you all are considered designated employees. And they have to be filed 30 days within assuming the office on an annual basis and 30 days of leaving the office. Now, we're going to get into this in a few slides too. What you have to disclose is going to depend on your category. And your category is going to be listed. Each department, which includes the Department of Consumer Affairs, has to have a conflicts of interest code where, based on the official classification, you might have to have a disclosure category of number 2, 3, and 4, or 5, 6, and 8. There are certain disclosure categories based on the position, the official position, that will require you to provide disclosure. So not everyone is going to have the same disclosure requirements on the Form 700, but everybody that's a designated employee is going to file a Form 700. Next slide, please. So this is highlighting the financial disclosures. No matter which category you fit in, this is going to be a point of emphasis. Next slide, please. Here's some of the disclosure categories. Again, not all of them. These are just some of the main ones that I'd like to just touch on briefly. So if you're in disclosure category 4, you have to disclose an economic interest where in a business entity, professional association, or individual is regulated by the board or an entity that offers licensing courses or CE credit. Now, having to disclose this, and I want to underscore this point, having to disclose it on a Form 700 doesn't mean that automatically disqualifies you for it. There's a difference between disqualification and disclosure. So I just want to sort of put your minds at ease a little bit. Having to disclose something is a separate requirement and analysis from whether you're disqualified from not being able to make a vote on a particular matter. Next slide, please. Again, here's some more economic interests that have to be disclosed, and here's the caps. So you would be disclosing $50 or more per source for gifts. Income is at $500 or more per source, okay? And they have real property interests, 2,000, and there's more. These are just sort of the main ones. And I just wanted to note there, the nonprofit is not considered a business entity. And there's a whole host of details and instructions on the Form 700. The Form 700 is also really good about providing examples. For example, investments. They go into whether a Roth is an investment that has to be disclosed, or a 401k. I mean, they go into all of these examples and hypotheticals and FAQs because everybody is going to have questions as to, based on their particular financial, personal circumstances, what of that do they have to disclose? Next slide, please. Let's talk about gifts. Next slide, please. any payment or other benefit that provides a personal benefit, which is pretty broad of a definition. And again, as mentioned before, you have to report the gifts that are aggregated at $50 or more per source. And I just want to touch on that. Some people get confused about the aggregating. So if you get $10 from a particular source, you don't have to list that. But of course, if you get $10 one month, $20 another month, $20 yet another month from the same source, you do have to aggregate those. And then you'd have to disclose the $50 from that source. Next slide, please. Sources of a gift or gifts aggregating $500 or more in a calendar year and or within 12 months prior to the time the decision is made. Here's another statute and regulation that you'd have to look at. And you can start to see that you have to, and I think this is always a really strong recommended practice, that you're tracking these gifts, because you don't know yet whether they're going to aggregate into certain disclosure amounts. So you want to just keep track of them. And then when they do, that's something that you're going to disclose. And you also want to not just know the amounts, but you also want to know the dates to know whether you're within a 12-month period. Next slide, please. Here's some examples of gifts, probably not surprising on any of these. But as you recall, that definition of a gift was very broad. So obviously there's more than these, but these certainly fall into some basic examples. Next slide, please. Honorariums, okay, which are different than gifts. Any payment that's made in consideration for any speech that's given, article written, or attendance at any public or private conference. Okay. Generally, honorariums are prohibited. So generally, you should not be receiving any payments for making those sorts of speeches, etc. Next slide, please. There are some exceptions, and just for the sake of brevity on this particular presentation, we won't go into the weeds, but generally, I want you to be aware that there's this prohibition, and then there are some exceptions that go into it, and we can certainly look into whether the exceptions apply. I do want to mention, and I'll probably mention, if I forget, please remind me, but the Fair Political Practices Commission does have an informal advice line that you can call, and you can either submit the request in writing, or you can call their hotline, and there's certain hours in the day where you can call and say, let me give you some facts here. Can you let me know if this is a problem? Is this a conflict? Is this something I have to disclose on my Form 700? Is this something I need to disqualify myself from voting on? You can pose this to the Fair Political Practices Commission. They have assistants built in as part of the department to kind of assist designated employees. So this is also something I wanted you to keep in the back of your mind, especially when we get into weeds of sort of exceptions for particular pieces. They can help us with that as well. Next slide, please. So here's an example for honorarium that's a charity. Okay, giving a speech and donating your honorarium to a charity. An individual cannot direct which charity gets the donation. The payment to a charity cannot be a condition of giving the speech. You cannot claim a tax deduction. You cannot be identified in connection with the donation. There cannot be any financial effect on you. Now, what some designated employees have chosen to do is they get into the weeds, and we do a lot of fact finding. This is going to work out for them if they really want to pursue a particular speech or a particular event. And then other folks are a bit more categorical, and they just say, you know what, I'm going to stay away from these. I'm not going to accept any payment for these. And it's a little bit clearer cut for them. It puts their mind at ease, and they don't have to worry about whether they've messed up or looking to get an FPPC violation. So that's always something to be thinking about. You don't have to wade into all of these details if you'd rather not. Next slide, please. Travel payments. So payments of travel for actual transportation and related lodging and subsistence are subject to the rules and limits on gifts for reporting on the Form 700. So you want to make sure, and this was one of the listed bullet points under gifts earlier, if you recall. So this is something that you need to be thinking about and tracking, and both with date and amount for purpose of reporting as a gift. Next slide, please. Of course, like any category, there's exceptions. And again, we'd want to make sure that we are looking into the weeds on these. There may be an exception that applies. I think we're going to talk about one on the next slide. And there's different permutations of what's following. But we still want to be tracking them. My advice to you is to track these sorts of things, and we can figure out if an exception applies. But the hardest thing to do is to go back and try to tabulate everything. It's much better to be proactive about doing those things, and then we can figure out whether an exception applies or whether it's something that requires a disclosure or not. It may be that you've tracked it and it's not something we have to disclose. It may be that you don't have to disqualify yourself, notwithstanding the fact that we have all of this tabulated. So that would be just a strong recommendation, because there's lots of exceptions, a lot of examples and permutations. And so we will have to take your facts and apply them to the exceptions and the statutes to see if you're fine and you don't have to make any disclosures, any disqualifications. Next slide, please. Okay, so here's still yet another exception. So we're going to move past this, but I do want you to be aware again that there's lots of exceptions to the general prohibitions. This one is travel payment from the official's public agency, travel that's connected with a bona fide business, trade, or profession that would qualify for a business deduction under federal income tax laws, unless the sole or predominant activity of the business, trade, profession is speech making. Okay, again, very fact intensive. Let's go to the next slide, please. Travel that's reasonably related to a legislative or governmental purpose. Okay, so why did we go on that? Why did we make that trip? What was the governmental purpose behind it? We're going to have to look into that. Next slide, please. Okay, here's some common law conflict of interest that I mentioned early on. There's a general, I would say, prohibition or concern that if there's going to be an advantage to you, we want to look and see if that's problematic. We obviously can't say categorically that that's automatically a problem and a disqualification, but it should raise a red flag for you when there is that benefit to you. And you can see some examples here. Next slide, please. I mentioned earlier the incompatible work activities. So here we do have a department policy on it, that the state officer or employee shall not engage in any employment activity or enterprise that is inconsistent, incompatible, in conflict with, or inimical to his or her duties as a state officer or employee. And of course, it's in the details what qualifies for all of those things. Again, I know I sound like a broken record, very fact intensive. Next slide, please. These, I'm not going to go into all of these because these are still very a bit more generic. What does it mean to be using the prestige or influence of the state? It's going to depend. Using state time and facilities for private gain. Okay, well, what was the private gain specifically? What did that look like? How were you advantaged? Again, but these are the sort of subcategories that we would be looking into, that the Fair Political Practices Commission would be looking into whether or not you are running afoul of these conflicts of interest laws. Next slide, please. Certainly, we have ethical standards that are apart from the Political Reform Act. And we want to make sure, and if you're a gubernatorial appointee, or a legislative appointee, we want to make sure that those standards of ethical conduct are met or exceeded. And so certainly that's also a piece that we want to look at, besides the basic are you prohibited or not based on a statute or regulation. There may be sort of an optics ethical component to it, and that's something we'll also be discussing as well. Next slide, please. Contracts. I mentioned this at the beginning. We want to make sure that there's no conflict of interest with the vote and the contract regarding that vote, that it doesn't directly benefit you, your spouse, in some way provides you a financial advantage. Next slide, please. So that we do have the Fair Political Practices Commission. That's the hotline number. The Form 700, as I mentioned, gives a lot of FAQs and examples. I will tell you that's been very helpful because a lot of people, they use the examples that a lot of people have questions about on the form. And the way the form works, you have sort of an FAQ explanatory piece, and then you have the specific form for that on that topic. Okay, so I'm sure we probably have a lot of fact-intensive questions, but does anybody have any other questions for me based on landscape?
Jeremy, I have a couple questions.
Yes.
So, is this the end of the conflict of interest, or is there more on, like, say, like membership in organizations and things like that? That's coming up later, or?
I'm sorry, say that part again about membership associations.
Is this the end of the conflict of interest presentation, or are you going to be discussing like membership in organizations and?
No, I mean, what I would say, a particular question about the membership associations, that in and of itself isn't a conflict. Okay, the question's going to be, what does the association do? How is that related to your official capacity on the assistance council? And it may be for example, it may be a situation where there is no conflict with the fact that maybe there's an association as well. That's okay. But there might be particular votes that might be problematic. So I guess the overall question is, if the question is simply having a membership association and being on the committee, that in and of itself isn't problematic. We would need to look into things a little bit deeper as to like particular votes, particular positions, for example. For example, I know folks that have been on boards and committees that are also members of associations, and the question is whether they provide an official position as a member of the association. Maybe the association provides the position separate from the member. There are factual wrinkles and ways to sort of avoid conflicts. So I guess maybe we could chat about what the particular wrinkle you might have on that.
So let's say I'm on the executive council for like a California Educators Association, and I obviously know I can't be like the legislative chair for that because I'm on this committee. But what about something like, let's say I wanted to run for secretary or vice president or president? Is that prohibited?
Well, so if I can't know right now. For example, we'd have to look and see what the duties of the secretary are versus the president. Because it could be that, the secretary may not be making a lot of policy calls, but the president might. That might have more of an impact. So it may be that the secretary is not problematic, but maybe president might be. We would have to look at that.
I see. So if I'm a voting member, I would just exclude myself from the vote if it had anything to do with my duty on the committee. Is that what you're saying?
That would certainly be the cleanest and safest approach.
Okay. And then if I, like, let's say I attend a meeting, let's say I go to like the annual conference and they're going to have a business meeting, and part of that business meeting is like a legislative update, but there's being taken just like an update. I can attend that part, right?
Yeah, so you would be, again, it's one of those things where we would be making sure that you're attending not in your official capacity, and you wouldn't be discussing any business that would come before the committee. You wouldn't be taking particular positions at this legislative update on particular matters that could come before the committee. So there's things we can sort of shape or make sure that we have you properly educated so that you know what you can and can't do. If you're simply participating and listening to a legislative update, that's not inherently problematic.
Okay, I have a couple more questions, but I just want to give anyone else time if they have questions too before I.
And I'm happy to also, I'm happy to talk with you offline about particular wrinkles as well.
I think I just have a couple more questions. One is, let's say we are, because there are educators on the council and our school provides funding for us to go to state and national meetings. We don't write those off on our taxes, but the college provides the funding for that. Is that considered a gift?
I think it could be. Yeah, so we would want to look at that.
Okay, so that's good. And then
because the gift definition is very broad.
I see. Okay, thank you. And then my last question is so we attend these meetings and the vendors are there, and let's say the vendor gives everybody like an electric toothbrush. So is that's considered a gift, right?
Yeah, that's yes. And so yeah, we would want to look and see what the fair market value would be for that. You could also choose not to accept it. That's another route that folks have taken. But yes, we would want to look and see what the fair market value is of that. The theory is if you accept a gift, at least behind the fair of a certain amount, that's why they have these dollar threshold. There's a presumption that based on the acceptance of that gift that has a fair market value of X amount, you are being influenced. So that's the theory behind it. So that's why we care about the fair market value. That's why we care about, well, how did you come to get this? Is this part of the convention sort of thing? Like, how did we come to get this? And do we accept it? Do we not? Because because acceptance of gifts is at least a presumption that they're influencing, the acceptance of it is an influence upon you.
Okay, that makes sense. Thank you very much. I appreciate that.
Sure. Well, that's all I have. Thank you all very much. And again, happy to answer any other questions if anyone has any.
Hi, this is Tina Valerie. Thank you, Anthony, for that presentation. It was very helpful. We're going to now move on to agenda item 8, California's legislative and regulatory process. I'll ask Gabe Nevin, the board's legislative and regulatory analyst, and Danny Rogers, board regulatory legal counsel, to present this agenda item.
Thank you, Tina. This is Gabe Nevin, legislative and regulatory analyst. Can everyone hear me?
Yes.
Yes, Gabe.
Thank you. So we're going to be talking about the difference between a statute and a regulation. A statute is a law passed by the legislature and signed by the governor, whereas a regulation is a rule that implements statute and is approved by the Office of Administrative Law. Now, the board has authority to write and adopt regulations, although the DAC does not. And you will be able to find a helpful glossary of legislative terms if you search for California legislative terms. There's one made by the legislature and by the Senate that are both excellent. And always, board staff will be available as a resource to answer any questions that you're going to have. Can we move forward a slide? 2 slides, please. Thank you. So the major players in the California legislative process are the legislators. That would be the Senate and the Assembly. And there are 40 senators and 80 Assembly members. Fun fact, the proportion of population to senators makes California senators the highest, represent the most people of any U.S. legislative house. The governor is another important player in this, as the governor will be signing legislation, and of course stakeholders, members of the public, professional associations are very important. So the legislature operates in 2-year sessions. The next session will be beginning this year, or this coming year, and it will be the 2021 to 2022 legislative session. The tentative legislative calendar is printed by the Secretary of the Senate in the Assembly Office of the Chief Clerk and is available online. There's also a helpful diagram if you search for life cycle of legislation. Now, if we can go to the next slide, I'll talk a little bit more about the life cycles. Starting with an idea, because all legislation has to start as an idea, and these ideas can come from anyone. The process begins when either an individual or a group, including the DAC, persuades a member of the, or the board, persuades a member of the legislature to author a bill. At that point, a member of the legislature will send the idea and the language for the bill to the Legislative Council's office, where it is drafted into the actual bill. The drafted bill is returned to the legislator for his or her review, and persons or groups that originated the idea for the bill may also review it to ensure that the provisions they desire are in the bill in the correct form. Both Assembly members and senators are limited to introducing 40 bills every 2-year session. So next is introduction, and if the author of the bill is a senator, it will be introduced at the Senate desk. If they are an Assembly member, they will be at the Assembly desk. There it is assigned a number and read for the first time. The bill is then sent to the Office of State Printing, and no bill may be acted upon until 30 days has passed from its date of introduction. And that bill numbers will be introduced as Senate bills SB or Assembly bills AB, followed by the number. Next, a bill will go to the Policy Committee, starting with the Rules Committee of the House of Origin, where it is assigned to the appropriate policy committee for its first hearing. Bills are assigned to policy committees according to the subject area of the bill. For example, a Senate bill dealing with healthcare facilities would first be assigned to the Senate Health and Human Services Committee for policy review. Now, during the committee hearing, the author presents the bill to the committee, and testimony can be heard in support of or opposition to the bill. The committee then votes by either passing the bill as amended, or defeating the bill. Bills can be amended several times, and letters of support or opposition are important and should be mailed to the author and committee members before the bill is scheduled to be heard in committee. It takes a majority vote of the full committee membership for a bill to be passed by the committee. Now, each House maintains a schedule of legislative committee hearings, and prior to a bill's hearing, a bill analysis will be presented that explains the current law, what the bill is intended to do, and some background information. These analyses will typically list the organizations who have gone on record supporting or opposing the bill. Next, the bill will go to a fiscal committee if it has a fiscal impact or state cost. And these bills will be heard either in the Senate or Assembly Appropriations Committees. In these committees, there will be an opportunity to submit testimony. However, it should be limited to a fiscal argument. The finance committees are concerned with fiscal impact and not policy considerations. Next, the bill will go to second reading. Bills passed by the committees are read a second time in the House of Origin and then placed in the daily file for a third reading. If a bill bill is reported without amendments, it is read the second time and then sent to the engrossing and enrolling office, where the printed bill is compared to the original bill, and after comparison, which is called engrossing, the bill is returned to the Assembly or Senate third reading file. In the event that the bill has been reported out of the committee with amendments, and these committee amendments or amendments offered from the floor have been adopted on second reading, the bill will be reprinted showing the amendments using strikeout for matter omitted and italic type for new matters added. Next, the bill goes to a floor vote. When the bill is read the third time, it is explained by the author, discussed by the members, and voted on by a roll call vote on the floor of the chamber of the House of Origin. After the floor vote, it will head to the other house, and that would be the second house. Once the bill has been approved by the House of Origin, the procedure is repeated on the other side. Now, if the second house amends the bill will have to go to concurrence in the House of Origin, where an agreement on the amendments will be reached. If an agreement cannot be reached, the bill is referred to a two-house conference committee to resolve the differences. 3 members of the committee are from the Senate and 3 are from the Assembly. The members meet to negotiate out the difference. If compromise is reached, the bill is returned to both houses for a vote. If the bill is passed, it is now waiting for the governor's action and is moved to enrollment. Enrollment is a process whereby the final version of the bill is printed, proofread to ensure that the language in the document reflects the final action by the legislature. And then the process culminates in the delivery of the bill to the governor's office. The governor has 3 choices. He or she may sign the bill into law, allow it to become law without signature, or veto it. Now, the governor has 12 days to consider legislation, and any bill that is not vetoed or returned to the governor after 12 days becomes a statute without the governor's signature. The exception to this provision occurs at the end of each year of the legislative session, when the governor is given 30 days to consider bills passed by the adjournment deadline of the legislature. Bills signed by the governor typically become law the next January 1, following the year that the bill was passed. However, urgency measures take effect immediately upon being signed by the governor and chaptered by the Secretary of State. Urgency bills affect the public peace, health, or safety and require a 2/3 vote for passage. The governor may also veto a bill or return it to the House of Origin without a signature. A letter explaining the governor's objections to the bill is printed in the journal and file of the House from which the legislation originated. Vetoed bills may become law without the governor's signature if 2/3 of the membership of both houses vote to enact the vetoed bill. Can I have the next slide, please? So, the Dental Assisting Council, under Business and Professions Code 1742, considers all matters relating to dental assistance in California, and on its own initiative or at the request of the board, makes appropriate recommendations to the board and the standing committees, including but not limited to the following areas. These are the requirements for dental assistant examination, licensure, permitting, and renewal, the standards and criteria for approval of dental assisting education programs, courses, and continuing education, allowable dental assistant duties, settings and supervision levels, appropriate standards of conduct and enforcement for dental assistants, and requirements regarding infection control. So the recommendations by the council under this section can be approved, modified, or rejected by the board, and must happen within 120 days of submission. If the board rejects or significantly modifies the intent or scope of the recommendation, the council may request that the board provide its reasons in writing for rejecting or modifying the recommendation within 30 days. So what does this mean? This means that unlike the board itself, the DAC does not initiate legislative proposals and does not take positions on bills. Rather, the DAC serves as subject matter experts, and their role is to assist the board by making recommendations. That's how the DAC submits legislative changes. However, stakeholders can seek authors on their own. So now, are there any questions about the legislative process before we move on to the regulatory process? Okay, seeing none. Can we move on one more slide, please? So, during the regulatory process, the board will submit regulatory documents, rulemaking documents to the Office of Administrative Law. That's also called OAL. OAL will review the submitted regulation and make determinations based on these 6 standards listed. OAL will approve the regulation only if it complies with these standards. So let's go into these standards. Authority means the provision of law which permits or obligates the agency to adopt, amend, or repeal a regulation. The authority standard is whether the agency has general or specific authority to adopt the regulation. Almost all state agencies have explicit authority to adopt regulations, and most major agencies have a general rulemaking authority. Next is reference. Reference means the statute, court decision, or other provision of law which the agency implements, interprets, or makes specific by adopting, amending, or repealing a regulation. After this is consistency. This means being in harmony with and not in conflict with or contradictory to the existing statutes, court decisions, or other provisions of law. It means that it must be consistent with the statute which is being referenced. This is because regulations are vehicles for implementing statutes. The authority of the agency to create a regulation is limited to the language of the statute, and therefore the regulation must be consistent. Clarity means written or displayed so that the meaning of regulations will be easily understood by those persons directly affected by them. Clarity is one of the main reasons that OAL rejects a regulation, and this is usually due to ambiguous or undefined terms used in the regulation. Next is non-duplication, and this means that a regulation does not serve the same purpose as a state or federal statute or another regulation. The standard requires that an agency proposing to amend or adopt a regulation must identify any state or federal statute or regulation which is overlapped or duplicated by the proposed regulation and justify any overlap or duplication. The standard is intended to prevent the indiscriminate incorporation of statutory language in a regulation. Finally is necessity. Necessity means the record of the rulemaking proceeding demonstrates by substantial evidence the need for a regulation to effectuate the purposes of the statute. This has to take into account the totality of the record, and for the purposes of this standard, evidence includes but is not limited to facts, studies, and expert opinion. So now the Dental Board's rulemaking authority is codified at Business and Professions Code 1614, and it specifies that the board may adopt regulations concerning the holding of meetings, the holding of examinations, the manner of issuance and reissuance of licenses, the establishment of standards for the approval of dental colleges and dental assisting programs and educational courses, prescribing subjects in which applicants are to be examined, the administration and enforcement of all of these other rules. So finally, these regulations will be found in the California Code of Regulations, or CCR. This is the codification of general and permanent regulations announced in the California Regulatory Notice Register by California state agencies under authority from primary legislation in the California codes. The CCR consists of 28 titles, but regulations pertaining to dentistry are found in Title 16. Therefore, you will see references to the Dental Board's regulations as 16 CCR followed by a code section. Can I have the next slide, please? So the regulatory process will start by identifying a need for a new regulation or a need to amend or repeal an existing regulation. all regulations are prompted by the identification of a problem that needs to be addressed by the agency through adoption in order to enforce or administer a statute. This can come from a legislative mandate, legislation requiring action by the board, or council members, or stakeholders, or staff identifying a problem, gap, or loophole in existing regulations, or a change of circumstances that requires a regulatory update. For instance, we have a regulation concerning mobile dental units, but since it was written, there have come into existence portable dental units, which are of a different definition, and so the rulemaking is being expanded to include those new units. So the preliminary activities begin once a state agency decides to conduct a regular rulemaking action. The agency will engage in research and gather materials and information necessary to develop all of the documents required to conduct a formal rulemaking. Generally, the rulemaking agency has discretion whether to include the public during this stage. If a proposed rulemaking action involves complex proposals or a large number of proposals that cannot easily be reviewed during the comment period, the agency will involve parties who are subject to the proposed regulations. This requirement is not subject to OAL or judicial review, however. When an agency uses the materials and information gathered during the preliminary rulemaking stage to develop at least 4 documents that are needed to initiate the formal rulemaking process. These documents include the proposed language. This will be the text of the proposed language that will clearly identify any changes to the CCR. Proposed additions will appear as underlined text, and deletions will appear in strike-through format. The authority and reference citations that follow the text of each regulation section identify the statute upon which the section is based. The notice of proposed action is another document. The notice contains a variety of information about the nature of proposed regulatory changes, additions to the regulatory, including various findings, determinations, and statutory authority, and the laws being implemented. The notice of proposed action also contains procedural information, such as deadlines for submitting comments, scheduling of hearings, if any, and where copies of the express terms, the other documents, and supporting information can be obtained. Next is the initial statement of reasons. This is a document that explains the reasons why the agency is making the proposed regulatory changes. This includes an explanation of the problem being addressed, the purpose of and necessity for and benefits of all of the proposed changes. The initial statement of reasons, or ISOR, also identifies the factual material upon which the agency relies in proposing the regulations. The ISOR includes a number of the required determinations, findings, and analyses, including either the economic impact assessment or standardized regulatory impact analysis. The economic and fiscal impact statement is found on Standard Form 399. This is a Department of Finance form that an agency is required to complete and have signed by the rulemaking agency's highest ranking official or their delegate. The 399 includes information on the estimated economic, that would be private, and fiscal, that would be governmental, monetary impacts of the proposed regulation. Rules governing the 399 can be found in the State Administrative Manual, sections 6,600 through 6,615. To initiate a rulemaking, it will be filed with the Office of Administrative Law. So to initiate the formal rulemaking action, the agency publishes a notice of proposed action in the California Regulatory Notice Register. The agency must also mail the notice of proposed action to those persons who have requested notice of the regulatory actions and post the notice, express terms, and the initial statement of reasons on the agency's website. Once the notice of the proposed action is published in the California Regulatory Notice Register, the rulemaking process is officially started, and the agency has 1 year within which to complete the rulemaking process and submit the completed rulemaking to OAL. This will begin a 45-day public comment period, which is required under the Administrative Procedures Act. During this period, the public may comment to the agency in writing on the proposed regulation. The notice of proposed action specifies the rulemaking agency name and contact person and address where comments may be directed, as well as the date that the comment period closes. The public regulatory hearing is optional under the Administrative Procedure Act for scheduling in advance. However, if an agency does not schedule a public hearing and an interested party submits a written request for a public hearing within 15 days of the close of the written comment period, then the agency must hold the public hearing. If a public hearing is held, the agency must schedule for a date at least 45 days after the notice of proposed action was published. At the public hearing, both written and oral comments must be accepted. The agency then has a duty to respond to adverse comments. So under the Administrative Procedure Act, a rulemaking agency must consider all relevant matter presented to it during a comment period before adopting or amending or repealing a regulation. A rulemaking agency must summarize and respond to timely comments that are directed at the proposal or at the procedures followed by the agency during the rulemaking action. For each comment, the agency must include either an explanation of how the proposed action has been changed to accommodate the comment or state the reasons for rejecting the comment. In summarizing and responding to public comments, the agency must demonstrate that it understood and considered the comment. The summary and response to comments is included as part of the rulemaking file in a document called the Final Statement of Reasons. In the case of the board, staff and legal counsel will prepare recommended responses for the board's consideration and approval or rejection during consideration. Now, if as a result of those comments, the rulemaking agency changes the initial proposal, or as a result of an internal discussion or other prompting, either in response to public comments or on its own, the agency can then decide whether a change is non-substantial or substantial and sufficiently related or substantial and not sufficiently related. Non-substantial changes do not alter the regulatory effect of the proposed provisions, and therefore no further notice is required. However, if a change is substantial but not sufficiently related to the original proposal, i.e. not reasonably foreseeable based on the notice of proposed action, the agency must then publish another 45-day notice in the California Regulatory Notice Register, similar to the original notice of proposed action. However, these changes are uncommon. The APA provides that a rulemaking agency must make each substantial, sufficiently related change to its initial proposal available for public comment for at least 15 days before adopting such a change. Thus, before a rulemaking agency adopts a change, it must mail a notice of opportunity for public comment to the public, or, oh, I'm sorry, sort of lost my place here. The agency must also post the notice on its website. No public hearing is required, but the public may comment on the proposed modifications in writing. The agency must then consider comments received during the comment period, which are directed at the proposed changes. An agency may conduct more than one 15-day opportunity to comment on a large, complicated, or sensitive rulemaking action before the final version is adopted. After changes to the rulemaking proposal are made as a result of public comment or on the board's initiative, the board must review the changes and adopt or reject them into the rulemaking file. After adopting the regulation, the agency prepares the final statement of reasons, in which it will summarize and respond to comments, as well as enumerating all changes made to the initial regulatory language. This will begin the approval process. The final rulemaking file will then be reviewed by board staff, legal counsel, the Department of Consumer Affairs Executive Office, as well as the Business Consumer Services and Housing Agency Secretary's office. Upon approval, the rulemaking file will be transmitted to OAL. Once it is filed with OAL, a rulemaking agency must transmit a rulemaking action for review within a year of the date of the notice of proposed rulemaking action was published. OAL then has 30 working days in which to review the rulemaking record to determine whether it demonstrates that the rulemaking agency satisfied the procedural requirements of the Administrative Procedure Act, and to review the regulations for compliance with the 6 standards. That would be authority, reference, consistency, clarity, non-duplication, and necessity. OAL may not substitute its judgment for that of the rulemaking agency with regard to the substantive content in the regulations. Now, if the rulemaking does not satisfy the APA's 6 standards, OAL will return the file to the agency and publish a disapproval in the notice register. At this point, the agency will have 120 days to revise the text, conduct another 15-day public notice and comment period on the revised text, and resubmit the documents to OAL. The agency may also appeal the disapproval to the governor's office. Now, approved rulemakings are filed with the Secretary of State. So this would be after OAL determines that the 6 Administrative Procedure Act standards are met and the rulemaking satisfies the APA. OAL will approve the regulation and file it with the Secretary of State for printing in the California Code of Regulations. Generally, regulations become effective on one of 4 quarterly dates based on when the final regulations are filed with the Secretary of State. If filed between September 1 and November 30th, they will be effective on January 1. If filed between December 1 and February 29, they will be effective April 1. If filed between March 1 and May 31, they will be effective July 1. And if filed between June 1 and August 31, they will be effective on October 1. Effective dates, however, can be varied if a different effective date is provided for in the statute or other law, or if the adopting agency requests a later effective date, or if the agency demonstrates good cause for an earlier effective date. May I have the next slide, please? So how can the Dental Assisting Council be involved in the regulatory process? Now, the Council, under BPC 1742, can consider all matters relating to dental assistance and on its own initiative or upon the request of the Board, make appropriate recommendations to the Board and the Standing Committee. Again, these recommendations shall be approved, modified, or rejected by the Board within 120 days of submission of the recommendation to the Board. And if the Board rejects or modifies the recommendation, the Council may request the reasons for this modification or rejection in writing. So again, this means that unlike the Board itself, the DAC does not initiate regulatory proposals. However, when stakeholders have relevant issues which they want to present, the DAC is the subject matter expert body to which they will present, and ultimately it will be the DAC that makes the recommendation to the Board. Does anyone have any questions about the regulatory process? I know that was a lot.
Kara Miyazaki, I have a question just about timeline. So when a, let's say an amended regulation is filed with the Office of Administrative Law, what's the least amount of time that it could actually be like a, I guess the last step is the filing with the Secretary of State. So is there like a range of how long things like this take from like the shortest, what's the shortest amount of time it could take and what could be like the longest? If you can answer that.
Well, so
Rogers, I'm happy to address that if you'd like me to.
Yeah, please.
Good morning, everyone. This is Danny Rogers, Regulations Counsel to the Dental Board. Ordinarily, the Office of Administrative Law would have 30 working days to review a regulatory package. However, because of COVID, those timelines have been affected by a couple of different executive orders. Ordinarily, while it would take 30 working days, it has been extended twice by 60 calendar days. So theoretically, it could take 30 working days extended by one extension of 60 calendar days and a second extension by virtue of a second executive order by an additional 60 days. So they have a total of 120 plus the 30 working days at this moment based on the state of emergency that's been declared.
Thank you.
Thanks, Dan.
This is Karen Fisher, the Executive Officer. I wanted to also interject that the timing is pretty specific only after the formal process has begun. So in many cases, the DAC or the board through a subcommittee may be working on regulatory language and working on it and trying to get it perfect, but the timelines don't actually affect it until it is formally initiated.
That's correct, Karen. If I could add a finer point to that, that's correct that once the notice of proposed action is issued, it's effective for 1 year from the date of the notice. And also there have been various extensions placed on that as well. It has been extended by the 60 days, the 2 sets of 60 days by virtue of Governor Newsom's 2 executive orders as well.
And just to interject an example, so the Dental Assisting Council regs that are on the board's agenda now to essentially approve the language and initiate it, those regs have been discussed in work groups where some former members of the Dental Assisting Council participated in those public meetings, and I believe it's been in the works for probably 3 years. So the process then, once it is formally initiated, then there are timelines in place. And that's where you hear us talk about the 45-day comment period. And then if we get comments back, those go back to the board to either accept or deny, and then it goes back out again for 15 days. So the regulatory process, I believe you can find the information, the very detailed information in your orientation packet that you should have received, maybe around like page 259 or in that area. But primarily, really what you need to be concerned about is staff, dental board staff essentially processes all this work and submits it to the different levels and responds back. What the DAC will be doing is you're going to be acting as subject matter experts for the language. And that's primarily what you'll be working on in the future. So it'd be awesome if you could also become pretty familiar with the process, but in the event that it's a little bit too much information too early, really what you just need to know is you are being utilized as a subject matter expert for regulatory language that will be moving forward.
Hi, this is Jerry Fowler. I have a question.
Go ahead, Jerry.
It's regarding the process for notifying the president and the executive officer for adding agenda items. Is that done via email?
Yeah, it could be done via email. It could be done by way of a telephone call. It could be done any way you'd like.
Okay, thank you.
Uh-huh.
Okay, well, this concludes our presentation.
Thank you, Gabe and Danny. Now we will move on to agenda item 9, question and answers from the public. Are there any Dental Assisting Council member questions or public questions? If so, please use the raise your hand feature. And moderators, if you could activate the public comment.
This is the moderator. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen. Type, I would like to make a comment into the ask field and submit that to all panelists. We will also be watching for hand raises. Thank you. At this time, I'm not seeing any hands raised, and we have not received any requests for public comment through the Q&A panel.
Hi, this is Tina.
Yes, thank you, moderator. Go ahead and close the Q&A panel. Sorry, Tina, go ahead.
That's okay. So that concludes, thank you, and that concludes the December 3rd, 2020 Dental Assisting Council training session. And I appreciate all of you for attending.
Thank you very much to everybody. It was very informative, and I look forward with working everyone.
Chair Miyazaki, thank you everyone also for the information. It was very helpful.
Tom Stewart, thank you everyone for attending and for your questions and your participation. Thank you so much.
Tracy Espinoza, thank you everyone and have a good holiday.
Jerry Fowler, thank you everyone, and I look forward to future meetings. Thank you.